On this episode of Unbillable, we mediate a case in a record 122 degrees, and then we get so passionate on why you shouldn't put people's names on your deeds that I pull the car over just so we could talk it out. Thanks for joining us on another episode of Unbillable. I'm everybody's favorite California licensed attorney, Amir Afsar, and I am literally sitting outside the Palm Springs branch of the Riverside County Superior Court, getting ready to go inside to act as a judge pro tem and mediate a case. Basically what that means is the court is going to give its authority to me to act as a settlement conference judge and see if I can help the two sides reach a middle ground and settle their case. I won't have authority to impose any kind of actual judgment or rulings on the parties. I won't be able to force them to really do anything other than hopefully participate in good faith and see if they can reach an agreement amongst themselves. I like to say that the mediators get a lot of credit when cases settle, but it's always the clients that do the hard work and make the hard decisions when it comes to the settlement of their case. So with that, I'm going to go inside. Mediations are confidential, so there'll only be so much I can talk about, but hopefully we'll get this case settled and I'll have something positive to say when I come back. All right, so we're back in the car and I got a couple confessions to make. The first confession I have is I got a phone call and I wasn't able to just record because I was on the phone the drive back from the courthouse. So I've already driven a ways back from the courthouse. Actually, some time has passed since the mediation ended. My second confession is that the mediation was not successful. I was not able to get the case to settle. The reality is, as a mediator, you only have a very limited amount of control. All you can do is encourage and discuss options with clients. They're not your clients, right? With their attorney, that attorney's clients, you can discuss options and available remedies and encourage them, give them reasons why you think it might be beneficial for them to consider taking one of these options. The moral of the story is, as a mediator, you do try to encourage settlement. I thought I had a very middle of the road and fair settlement, a settlement that I thought both parties should have agreed to, but unfortunately, although one party was agreeable to the idea, the other party just wasn't willing to do it. And again, as a mediator, all you're really doing is bringing two parties to the table in hopes that you can get them to make some kind of agreement. I like to say that imagine two people reluctant to shake hands. You're going to grab each of them by the wrist and try to pull their hands together to make a handshake. Unfortunately, while I had one guy by the wrist and had one hand in the middle, I was not able to get the other person to do it, and so we were not able and were not successful in resolving their case. So their case lives on. They have a trial setting conference in a couple of weeks. Basically, that's a hearing where the judge will give a trial date to those parties. In the meantime, I also want to talk about something separate from mediation. We've had an Unbillable episode talking about mediation, and so I kind of want to stray away from that for this purpose to say the following thing. If you own real estate, don't put someone else's name on it. I'm going to go ahead and pull over for a second here. If you own real estate, don't put someone else's name on the property. That's what I really want to drive home today. I've had 2 or 3 cases now. That's actually a lie. I've had like 5 cases probably now where the dispute is really about two people who don't get married. So they don't want to get married. So they believe they're going to be together forever. That's what they tell me. But they don't get married. And that's fine. I'm not trying to judge people on whether or not they get married. It's none of my business. I'm not here to give relationship advice. That's for damn sure. But the point is, you're not married, but then you go ahead and buy a piece of property, a home, something that might cost $200,000, $400,000, $800,000, and you put the other person, the boyfriend, the girlfriend, you put their name on the deed. You take deed as joint tenants. Joint tenants means that you both have a right to possession of the property. Neither party has to pay rent. You're both owners of the property. So when you put someone else's name on that deed, you must do it with great caution. I mean, you're really giving them half of the property. When you write joint tenants with right of survivorship, what that means is each party has a 1/2 interest in the parcel, and whoever dies first, the other automatically inherits that person's half, making them the sole remaining survivor and the owner of 100% interest in the property. Putting someone else's name on the deed effectively gives them that interest in the property. And then you also have to think that the court system, we rely on deeds. we rely on the documents recorded in the county recorder's office, grant deeds, other kinds of deeds like quitclaim deeds. The court system relies on that documentation. And if there's a dispute sometime in the future, because again, I know you believe the relationship's going to last forever. I get that. In that moment, you think everything's going to last forever. Caveat, you don't get married. You don't get married. That's just an interesting wrinkle that's going on. And again, that's fine. You don't have to get married, but you also don't have to put someone else's name on the property. And when you do that, you're giving them an ownership interest. And then sometime in the future, God forbid, your relationship falls apart for any reason at all, you're going to try to claim that I'm the one who paid for the property. They never paid anything. They didn't give the down payment. They haven't been paying the mortgage payments. I'm the one making all the payments, and they're not entitled to anything. And all they're going to do is say, look at the deed. Look at the deed. And the deed's going to say that you're joint owners, 50-50. And the court system's going to do what? It's going to assume that the deed is accurate. There's a presumption that the deed, the recorded deed, is accurate. So the court's going to make that assumption, and then the court's going to rely on that deed, and you're going to have to provide a reason, an explanation as to why that deed should not be relied on or why that deed is invalid. And this is going to take some actual evidence to show that a deed that's been recorded, oftentimes for years, the years of the relationship, frankly, why it should be invalidated by the court. And that's a hard showing to make. So again, if you're not really meaning to share a property with someone, no matter what your relationship status is, regardless of the status of your relationship, again, that's important. Then if you care enough where you're just, no matter what, I want them to have the property, then go ahead and put their name on the deed. But if when this relationship ends, you think you're still the owner of the property, don't put their name on the deed. Don't do it. Please don't do it. I guess that's going to go ahead and wrap up this episode of Unbillable. If you've enjoyed this episode, make sure you hit the like button. If you got a question or something you want to share with me, please comment below. And of course, subscribe if you want to keep up with the channel and all the new and exciting things that are going on with me and I guess the legal system and legal topics that we talk about on a vlog-to-vlog basis. Make sure you subscribe. It means a lot to me. All right, thanks a lot, and we look forward to seeing you on the next episode of Unbillable. Woo!